Okay. Hi, everyone. I am Stacy McNulty, and so I am doing the beginner clinic. This is my favorite thing to do for the mock trial. I volunteer a lot, but I really like doing this because when I was in high school, I didn't know any lawyers. I had no concept of what a trial looked like, what anything meant. And so when I eventually went to law school, I started learning that. And so like, I wish that I would have had something like this. So I might go over some things that you do know, but I will go through I just want to go through the basics, and then give you lots of like food for thought, examples, and also how to think about things. So hopefully you guys will be prepared. So if you have questions, of course, put them in the chat. We'll try and address them. But I think I'm going to kind of go through different chunks, and then I'll address all the questions related to that at the end.
Yeah, and as we've done every year, if you are particularly shy and you don't want anybody to know you've asked a question, you can send it directly to me. I won't read your name, I won't call you out, and then your question will still get answered. There is no question that's too dumb for you guys as the beginners. Like, please ask any questions you have. But like Stacy said, we may just like do them in chunks rather than interrupting the presentation. So with that, Stacy, I'm gonna let you take over until we're ready for some questions and stuff.
Great. And then the one thing I wanted to say too is I know that people get very anxious about objections and talking through that. I'm going to talk about that at the end. So just those types of questions, I feel like every year we get them like flooded at the beginning. So just know that like we're going to go through that stuff. So don't worry. Okay, so we're going to start, and I'm just going to go through briefly what a trial looks like. Kind of understanding the bigger concepts, I think will really help you as you're putting your case together and doing, your parts of putting on your witnesses. So we're going to just say, like, what does a trial look like? Let me move this. Okay. So there are parties, order of events, and the types of evidence. This is pretty quick. There we go. Okay, parties. There's plaintiff and defendant. I believe it is a civil case. In a criminal case, there is the state and the defendant. So the plaintiff has the burden of proof. You've got the elements of the cause of action. They're bringing the case. They filed a lawsuit. So it's the plaintiff's job to prove the elements of their claim with evidence. So that is why in a trial, a plaintiff is always going to go first. They're going to give their opening statements first. They're going to present their witnesses first. And that is why, because it's their job to prove their claim. Defendant does not have the burden of proof. So if you watch, like lawyer TV shows, oftentimes, the defendant doesn't have to prove anything. So in theory, a defendant could do a lot less during a trial. Defendant's counsel could do a lot less during a trial, but a defendant still needs to tell their side of the story. And especially for this competition, like you want to display all of your trial skills. And so because the defendant doesn't have the burden of proof, that's why they're always going to go second. So they're going to follow the plaintiff in opening statements. They're going to present their witnesses second, their case in chief, or their case second. And they're going to do their closing statements second. So opening, plaintiff, defendant. So this is just, and you can refer back to this later. We'll make sure you have this, but there are some kind of things that you just need to cover during opening. Introducing yourself, your witnesses, but you really want to think about your theme. We're going to talk about that later, but it's going to be kind of your tagline that you're going to repeat, and hopefully it's something that like sits with the jury that makes sense to them. And the purpose of opening is to tell what they're going to see. So we're going to tell them the elements of the claim, and you're going to say, you're going to say, we have to prove there was a valid contract. And then you say, we are going to bring Ursula to the stand and she's going to tell us she made a clear offer to Ariel. I just gave away what our sample case is, but, and then you're going to repeat your theme. So that's kind of like the things you want to hit during opening. Defendants is very similar, except for instead of like walking through all the elements that have to be proven, you're really just going to highlight like what the plaintiff can't prove and what you're disproving. So the plaintiff's case is the plaintiff putting on witnesses and entering evidence. So there's 3 witnesses that will come up. So the plaintiff's lawyer puts on the first witness on the stand. Defendant counsel cross-examines. So then they get to ask questions to follow up what happened on direct. You can redirect as necessary, and then there's recross. So it goes plaintiff, defendant, plaintiff, defendant. Recross is really only as necessary. It's going to be very limited, and the judges are usually going to keep the scope very small. So don't plan on doing that all the time, I guess. So you repeat that process for each of the 3 witnesses, and then the plaintiff rests. Then we've got the defendant's case. It's the similar structure where there's 3 witnesses. Obviously, this time it's the defendant putting on the witnesses. So they bring person number 1. Plaintiff's counsel gets to cross. There's redirect if you need to, and then recross as necessary. Again, that is not something that, it's never really that great. So that happens for each of the 3 witnesses, and then the defendant rests. Their case is over. Here's objections. And so I'm only bringing this up now to say that that happens during each of the witnesses. So if you are going to be the lawyer that's going to be doing cross-examination, that's when you're the one who's going to be objecting. That's in the rules, but I just wanted to highlight that. You also will have these sheets, but this is kind of just telling you like what exactly you have to do, and what it looks like, and you can just refer to this later. Then there's closing statements, and then there are rebuttals if reserved. Usually the plaintiff will reserve some time because you kind of want to have the last word. So the purpose for the closing statement is really you want to walk through the elements, but you want to highlight like your best evidence that proved or disproved, and then you need to tell the jury what you want them to do. So really, if you think about a trial from the big picture, the goal is to have the jury rule in your favor. So it's very important to tell the jury what you'd like them to do and tell them how they can do that. So I think that sometimes people forget that. So there is a jury form, or you can pretend it's a jury form, and you tell them, you're going to get this paper from the judge. It's a jury form. It will ask you these questions. Did we prove these elements? If you're the plaintiff, you're going to say, because of this, we're going to ask that you find we've established a contract, something like that. But you're going to use that, so that gives the jury a tool, and gives them like clear instructions. So I just wanted to point that out because I think that people lose sight of that goal, is that the jury actually needs to do something. You're going to go back through the elements. You're going to walk through the highlights, your best evidence. Always a good idea to address like evidence that the other side that you got from someone else's witness. And then always like bring back your theme unless it's completely shattered, but you probably still should, just because if the jury heard about it during opening, they really you kind of want to like bookend it and address it during closing. Types of evidence. There's witness testimony. This is in-person evidence. There's exhibits. So like in your case materials, it's going to be a document basically, or a physical item, and that's got to be entered into the record. So then it becomes a part of the entire case record that the jury can rely on when they're making decisions. And then there's demonstrative evidence. And so this is more like an illustration or a map or something that's going to help you demonstrate or illustrate something that would otherwise be kind of like difficult to understand. So I think of demonstrative evidence as like really useful tools, and I think you should try to use them. And you should absolutely make it a goal to use all of those types of evidence. So, you know, I think when I judge teams, the best teams are the ones that, of course, you're going to use witness testimony because you have to call them. You're going to do much better if you're, you know, entering and using lots of documents. But then the best teams also are going to use some type of demonstrative exhibit. So, you know, like a overview, you know, if it's a case about, I don't know, land. So if you have like an overview of the property, something like that, so that people can point and the jury can see. Okay, we will address these objections later. So I'm going to now go to Okay, so this is the important, I think this is the most important part of learning how to put on a case, is how to think about it and how to go through all the case materials, because you get a big packet, and how to actually put that into practice to present your case. So this section, we're going to go through a sample case, which I told you earlier that it's about the Little Mermaid. And then we're going to talk about how you dissect the case, like actual steps that you should do every time. And then how to make the plan, how to make the outline that will be your case presentation, whether you're the plaintiff or the defendant. Okay, so this is just, we're going to use a kind of a sample case. It's not perfect, but it will help us kind of give examples as we're going through all of this. So I'm hoping that you guys are all familiar with The Little Mermaid. I was born in the 80s, and so we're doing like the 1989 version. I know there are some factual differences with the live action version, although I do love that one. So we're going to do a contract dispute based on The Little Mermaid. Here, Ursula is suing Ariel for breach of contract. She says that Ariel breached the contract when she didn't kiss Eric by sunset on the third day. And because of Ariel's breach, she has to be turned into one of those sad seaweed things that's in Ursula's lair. Ariel's going to say there's not a valid contract, so she doesn't need to turn into one of these seaweed things. And so what we're really focusing on in the dispute here is whether there's a contract. We're really not going to talk about whether it was breached, because we all know that she didn't kiss him by sunset. So just to quickly kind of go over what happened, in case you're not familiar, but Ariel fell in love with the prince. She went to the sea witch and asked her to turn her into a human. Ursula said, okay. She sang a song. She said, I will do that, but I will take your voice. And she said, if you don't kiss him by sunset on the third day, I will turn you into this sad seaweed thing you see here. And I will, she says, you belong to me, which is not a legal purpose. You can't really own another person. So we're going to ignore that. So that's kind of what happened. We see here that, you know, what happened during the movie. So let's talk about how we're going to dissect that in the context of this contract issue. So when you have all these materials, it's kind of overwhelming. So the very first thing you should do every time, this is what, as a practicing trial lawyer, this is what I do, is you need to go back always to the elements of the cause of action, because this is what has to be proven with evidence. You can't prove that, you know, if you get lost in the minutia of everything, you're going to sell yourself short, because this has to be the focus. So first, read the elements of the cause of action, print it, put it to the side, and have it handy. Next, review the witness statements for both parties and review all the exhibits so that you know kind of everything that's out there. That is, I mean, in your case materials, like that will take some time, but you just kind of need to know what's going on. And then next, go review again the witness statements and exhibits, the witness statements for your witnesses, and then the exhibits that are relevant to your case and what you need to prove. So if I was Ursula, who's suing for breach of contract, I'm going to review all the evidence and witness statements that I get in my case package. And then I'm going to go back to Ursula's specific witnesses that she will call, and it will say that in your case materials. Okay. Oops. Okay. Then after you've, sorry, I missed the most important step. It's, well, last slide. Then after you've read all that stuff, you go back to the elements of the cause of action and you say, all right, let's match the evidence that goes to prove each of these elements of the cause of action. So you're reviewing all the evidence and you say, okay, let's match it up. And so which are the best things to prove each of these elements? So I'm going to go through kind of, because we're having a contract dispute. So here, the cause of action for breach of contract has to be a valid and enforceable contract, which is offer, acceptance, mutual consideration. The enforceability part of it is actually 3, but we're not really talking about them. So it's that the parties are capable of forming a contract, the contract's for a legal purpose, and it's in writing. So all these parts that are italicized, those are elements that are not in dispute by the parties, and so we're not really going to focus on them when we're doing our examples. So the elements, there's the valid and enforceable contract. There is performance or partial performance by the plaintiff. So Ursula performed her requirements. There is a material breach or non-performance by the defendant. So Ariel didn't do something she was supposed to do. And then the plaintiff was damaged as a result of the breach. So that's just the elements. Ursula must prove by a preponderance of the evidence. We kind of went through those. I'm going to go in more detail on offer. The offer has to be communicated to the party that's accepting, and the terms when communicated have to be sufficiently definite and clear so that if, you know, I just said, I accept, all of the contract would essentially be defined, and the parties would know what their obligations are specifically. Acceptance has to be clear and unequivocal is usually what they say, but they have to accept the terms that are offered. So it is not acceptance if you say, I'm not going to do that part of it, but okay, I accept. That's changing things. So if to have an actual offer and an acceptance, it has to be accepting the terms that were originally presented. And then mutual consideration. So the parties each have to exchange something that's of value. Consideration could be like performance. So you do something. It could be you don't do something that you like are allowed to do or could otherwise do. Or, you know, like some type of value. So we're not going to focus on like the legal aspects of all of this, but these are the 3 elements. A, B, and C is what we're going to focus on for our dispute. So I wrote up here just like disputed. So Ursula must prove these things. So here's kind of like how, when I went into the more descriptions about these elements of the cause of action, you have to kind of think about how they might, you know, be met or not met. So was the, for an offer, was the offer communicated to Ariel? I mean, maybe it wasn't. Were the terms of the offer clear and definite? So, for example, did Ursula explain exactly what she would do and what Ariel had to give to her or do? Acceptance, did Ariel accept the terms as they were offered, or did she try and change things? And then consideration. So, you know, Ariel got legs in exchange for what? Ariel got to stay a mermaid in exchange for what? See, and then Ursula, you know, she turned Ariel into a mermaid in exchange for her voice. So now you make your plan to prove each of these with the evidence. So here's an example for the plaintiff, Ursula. I'm just going through these again, because you always want to have the elements handy. The plaintiff should go, Ursula should review the statements for the plaintiff's witnesses for, you know, things that support any of these elements. And so after you read the materials, what you want to ask yourself a question for each of those elements. So how do I know that there was an offer communicated that was clear and definite? So I always like to ask myself a question like that, like, how do I know this? Because that's kind of gonna what leads you, you know, like logically to that's the evidence. So the answer is going to tell you the evidence that you're going to use to prove the element. But there could be more than one way to prove an element. So when you're putting your case together, you should be prepared to use both of them or all of them. There's usually one that's best. But if for some reason, like, you can't use this testimony or you can't rely on this exhibit because the other party objected and the court sustain their objection, then you're going to have to be prepared to prove that element with different evidence. So yeah, I like the how do we know question for each element. It really helps me. So how do we know that Ursula communicated an offer to Ariel that was clear and definite? So if I was Ursula's counsel, I'd say, all right, I'm going to call Ursula as a witness, and she's going to testify. I'd say, did you tell Ariel these terms out loud when you made an offer? I'm not saying did Ariel hear them? I don't know what she heard, but I want to establish that Ursula said it out loud when they were together. I'd say, did you tell Ariel that you'd turn her into a human in exchange for her voice? Because I want to establish that there was this consideration, that it was clear what she had to do. Did you tell Ariel that she could stay a mermaid if you kissed Eric by the third day? Did you tell her if she didn't kiss Eric, she'd be turned into a seaweed pet? So those are all the things that I would ask Ursula to confer. I'd ask her, I'm hopeful she said yes, but I would ask all those questions of Ursula, my witness, to establish that she made this offer that was clear, definite, contain all kind of the terms that would need to be accepted. I would also think about, when Ariel comes on the stand in the defendant's case, I would ask her too, did you discuss the details of the offer? Because that tells me that she heard them. They were on the table. So if in the movie, you hear like Ariel say like, but without my voice. And, Ursula says, you'll have your looks, your pretty face. So it's clear that Ariel understood And that was part of the offer, that she would have to exchange her voice. So here we go. So the evidence of the terms that the offer was clear and definite. This is not this pictures aren't documents, but Ursula essentially like painted pictures for Ariel to explain the terms of the offer. There has to be love, and there has to be a kiss, but it has to be the true love kiss. So like she made it very clear that her offer required a kiss at this time, a true love kiss. She even painted pictures so that Ariel would understand what would need to happen. So here's also like example of evidence of the consideration. So how do I know that the parties exchanged, there's consideration, someone got something. And so, I would ask Ursula, did you get Ariel's voice? And she would say, yes, I got this glowing ball that I kept in a shell on my neck. So that, that's saying, okay, Ursula got that consideration. Did you turn Ariel into a human? Yes. So that, they're exchanging these things. I'm sorry, those are out of order. Evidence of acceptance. How do we know Ariel accepted Ursula's terms as they were offered? And so this is different because instead of a witness, we've got an exhibit, a document. So the exhibit would be the scroll here that Ariel signed. So that would be an exhibit. That would be evidence that Ariel accepted her terms as they were offered, because Ursula will tell you all of her terms were spelled out in the document. And she'll also tell you Ariel signed, and you'll see that in the exhibit. So there's the exhibit itself that you would want to enter. And then there's the testimony. So these different types of evidence that are both going to establish acceptance. Okay, so here's an example for Ariel disproving the elements with evidence. Oh, there's an example. It is pretty hard with the fact pattern in the movie, but just know that like in the case materials for mock trial, your witness statements, your exhibits, I mean, you're gonna have to comb through them. They're very dense. So there's going to be lots of evidence going both ways. Lots. So this is just kind of like example questions that like you would use that are relevant to each of these like elements of the claim. Hard to prove, as I said, with the fact pattern. So creating a theme for your case. So this I talked about or mentioned earlier is that this is a short, memorable phrase that's compelling. It's your elevator pitch. So for example, in the O.J. Simpson trial, if the glove doesn't fit, you must acquit. I mean, everybody, we just know that. This is an old template, but like there's a different case. I would say like in Ursula's case, your elevator pitch could be something like you have to stick to your, you have to do what you say you're going to do. Something like that, where everyone's like, oh yeah, that's true. And I can remember it, and it's short and it relates to claim and what we're going to show. So that theme would come in, you've got to introduce it first in opening statements, and you're going to bring it up during direct and cross exam. So, as Ursula's lawyer, when I'm talking to Ursula about when they agreed to the terms and, the scroll, could say like, you've done lots of these spells for people. Do you expect them to do what they say they're going to do? And, yes, of course, like, why else would you trying to get into an agreement? you know, so that just bringing that up again and again is helpful. Or just, in particular, if you can make the other side's witness like agree with you, or say it is even better. So like, you know, asking Ariel, like, if you're saying, you know, if you say you're going to do something, or if you promise someone you're going to do something, you should do it, right? I would also actually, for Ariel, I would establish that she has a history of not doing things she said she would do, like singing in the performance for her dad or being on time. So that's just a way to like bring it up in multiple ways, but definitely, you know, using another side's witness against them is great. And then during closing statements, you're going to repeat the theme again. So back to like process, you're going to take your elements and you're going to create an outline, a proof outline, basically. So you'll do your proof outline that says, here's what proves each element. And then you're going to do scripts for your direct and cross examinations. So we just talked about this, but you're going to do an proof outline essentially. So I like to, under each element, write down witness that can establish this element, and then exhibits, and then witnesses that can establish this element through cross. So like we talked about before with Ariel, you know, on cross, I can establish that she accepted the offer and signed the scroll. So that would be great. I would, of course, ask Ursula about it, and I would use the exhibit, the scroll, but then I would also want to revisit it with Ariel during cross. So one of the reasons I said before you want to review the entire packet of case materials is because you want to know the other side's proof too. So you need to be aware of the ways that the other side may try to discredit or disprove your evidence. So just be aware of that. And that's important too, because then if you're aware of how they might use it or what they might say about it, you know, if, for example, Ariel's counsel will probably make a big deal about the fact that Ursula is a witch and tries to make people her pets, you know, just kind of discredit her. So strategically, I wouldn't make Ursula my only source of evidence for these things, because she's like maybe not the most credible. That's why we want to have Scroll to maybe have Flotsam and Jetsam also testify about what they heard and saw when they were singing Poor Unfortunate Souls. So then you're going to make the scripts, basically outline of points you want to establish, and then your scripts for your witnesses. So you're trying to tell the story, the witness's story, trying to tell the case through the witness's story. So, and you want to make sure you establish all the elements and hit on all of the elements of the cause of action that the witness can. So certainly, they can't all witnesses can't do all the elements, and that would be pretty tedious if they did. In the direct examination scripts, you're gonna also want to think about exhibits that you want to enter and how you use them. So with Ursula on direct examination, I would say, Ursula should talk about the scroll itself, and then I'll introduce the scroll so the jury will have her testimony and they'll have this actual scroll. And then you also want to think about when you're making this direct examination script, like taking the sting out of bad facts or explaining things that maybe don't look good. So, you know, I imagine Ariel's team would make a big deal about the fact that Ursula is a witch and maybe doesn't have the best motives. So, you know, I'd say, you know, what if in the song she says, like, in the past I've been a nasty or something. So I'd say, oh, you know, like, in the past, have you been nasty? And she'd be like, yes, I have, but I am trying to help people. And you know, I do for them what they ask me to do. And you know, but I don't do it for free. So that's how, for example, indirect, I would kind of address that weak point up front. So you're going to make your direct examination script, and then you're going to write your opening statement. That sounds backwards, but you want to write your opening statement that refers to this testimony, because it's important in opening to say, you are going to hear Ursula. Ursula is going to testify about how she made a clear and definite offer to Ariel during the song Poor Unfortunate Souls. So but you need to know that happened, and you need to make sure that you can establish that through testimony before you start making promises and opening. Then you should make cross scripts, you know, going through the other side's witnesses. And then you'll write your closing statement. So first, direct scripts, opening, cross scripts, closing, because you want the closing statement to mirror the opening statement, and it wants to deal with all that evidence that came out during trial. But when you're first drafting your closing statement, you need to keep in mind the evidence that you have control of. So in closing, you don't want to talk about what the other side's may say, or what evidence or exhibits they may introduce if you're not really planning on it. So only talk about points that you know you can make. So I know in my closing statement, I can say, and Ariel admitted that she signed this scroll that contained all the terms, because I know I can prove that. Okay, it might be a good time for some questions on just like kind of dissecting the case and stuff like that. Does anyone have any? Yes. Okay. So will this PDF be available to read? Yes. So these will be made available to you guys. How do you admit evidence? We're going to go through that actually in the next chunk. So I'm happy to start that if you guys would like me to move on. Okay. Will it be emailed? I don't know if it will be posted on the website, but it will be emailed. I know that I know that last year I think it was circulated. So
yeah, I think Melissa will send it out to everybody once we're done. And she'll probably also send out the links. It may be on the website as well, but we'll make sure Melissa gets it so that you guys can have all of that.
Okay, one question is, are there any specific number of questions on the direct or the cross exam? That's a good question. We're going to go into like a lot of detail, but I would say when in the general outline of like what a trial looks like, there are time limits. So if you have, if I'm Ursula's counsel and I've got 3 different witnesses that I'm going to call, even if all of the witnesses could talk about all of the elements, great. But that's not, I don't have enough time, frankly, to do that. So you do have to make judgment calls based on your time limits. Also on just like if it's getting boring. It sounds kind of silly, but on direct examination, you do want to kind of like, you can have more questions because you also want the witness to be just kind of familiarizing themselves and telling a story. So that would I would be creating more questions for direct than I would be for cross. So I think the rest of the questions we will respond to when we get to this like next section.
I would just add that for the initial direct and cross, there's not really a specific time limit, but when you're looking at redirect and recross, redirect, if you're asking more than 5 or 6 questions, you're probably covering more ground than you need to. Redirect, the purpose is like, okay, on cross, they're going to try to highlight the worst things about your witness. So on redirect, you want to clean that up. You want to try to leave the witness on like a positive note with the jury. And then recross, 2 questions, 3 questions. Again, if you're asking more than that, you're just going back over the same ground that we've already talked about.
Right. Because the scope of especially requests, so it's limited to what was asked about earlier. So like by the time you get to recross it, this has been covered. So it better be a really good point in a very succinct, short question.
I think the one example I have was a couple years ago, we had a witness who got paid like $3 million or something ridiculous to be an expert witness. And the recross was, so just to clarify, you got $3 million for your report in this case, correct? And it was like, yes. I was like, great. That's just what they wanted to leave that just witness on.
Remember this person might have an interest in.
Yes.
The other, so before, I think one thing that reminded me is, so before I talked about how in direct you might want to consider taking the sting out of things. For sometimes like that's not the best, like you really don't want to bring it up. So, and maybe you really don't know how much the other side's going to get into these like yucky issues. So redirect is a great, like that, the function there is where they did bring it up. They brought up that Ursula is a nasty and she has turned a whole lot of people into these seaweed pets. And you're like, okay, I didn't want to address that at all, but like, you know, to be fair, did all these people ask you to like turn them into a human or change them materially so they could get something that they wanted? And she's like, yes. And like, did you do that for all of those people? Yes. And did they get what they wanted? Yes. And so why are they your pets? Oh, they didn't do their part. You know, it's like, that's kind of how you'd like, if you chose not to do it initially, that's absolutely the time and the best way to use a redirect, I think. We're getting more.
When you're trying to establish credibility or discredit somebody, is there anything off limits to go for? The only thing I would normally say is you kind of want to make sure you're not making personal attacks instead of like, but we really try to build into every single witness statement something that would undermine their credibility, something where like they've changed their story in some way, or well, now they're getting paid a huge sum of money, or something to show that maybe there's some reason they're not being trustworthy. Sometimes you have to dig for it. Sometimes you have to try. But anything and everything. So any discrepancy in their statements can be used to discredit them. You know, anything they say that's like substantively different from every other, like if 5 witnesses all say the same thing and 1 witness says something different, you know, that could be used to discredit them. I'm not saying any of this exists in this year's problem. I honestly don't even know. So, but those are things we've done in the past. Or you have someone who maybe, you know, like investigators who didn't fully investigate the case, like they skip a substantive step. Or last year we had, what do we have? We had an investigator who like did their investigation and then, oops, accidentally deleted all their video footage.
Oh no.
Oh no. So anything that's in there that can be used to discredit somebody where you go like, I wouldn't trust this person. Absolutely fair game. Please use it.
Yes. And so that's all, when it comes to objections too, just as like a fun tip. So like whenever you're saying like this goes to the credibility of the witness is always like a great response that typically means you'll get it in, get the evidence in. Okay, I'm gonna go now into cross and direct more specifically in this next little chunk of slides.
Yeah, so that's going to answer the last question that was asked about leading questions into redirect. So we're going to ask, Stacy's going to go over what direct questions are versus leading questions. And so hopefully that'll answer your question. If it doesn't,
and if it's not, like,
ask
please.
it.
Yes, absolutely. I want to make sure you all are feeling prepared. Okay, so let me, you know what? I'm going to pause my sharing. Can we have like a 2-minute break while I make sure I'm pulling up the right
yeah,
set of slides? So let's meet. It is now 11:56, or sorry, it's 10:56. So at 11, let's meet back. I'm in a different time zone. So at 11 o'clock, we'll come back with the other set of slides.
Yeah. Okay, it's 56 after at 00. We'll come back and start again. So go grab a drink, go to the bathroom, anything you need to do. And if you have questions, you can drop them to me in the chat. You can send them to me directly while Stacy's getting set up for herself.
Okay. Oops.
Stacy, are you ready?
Sorry about that. Okay. Oh, give me 1 second. Where are we? Okay. 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 Let's see. Hold on a second. All right. There we go. Share. Oops, hold on. Let me go to the beginning. Sorry about that. Okay. Okay, sorry about that. Okay. So we're going to go into examination and entering evidence. Okay, direct. So for direct examination, you really need to keep kind of like the purpose in mind. And the purpose is really to have the witness tell their story and establish these points and prove the elements for your case. And so if we think about the witness, this is testimony, this is in-person evidence. So the witness is the star of the show. They need to be the ones to actually say this evidence that establishes the points you need. So if you're thinking about who's doing the majority of the talking, the witness is the star of the show, and the lawyer who's doing the direct examination, you're really just kind of letting them lead. So the attorney's job is to ask questions that will guide the witness, like signposts, to make sure that these important points are said. You need to be careful. That being said, you need to be careful. This is not just like a speech by the witness. So that's why I suggest making a script so that both you and the witness know like what's important that we want them to be able to say, but also how you can guide them to make sure we hit all of these elements of the claim. So the questions need to focus on what your witness has personal knowledge of, and that's, their witness statements, what they saw, heard, observed, and know. And so they should be formatted to use who, what, where, when, why, and how. I think did also kind of comes into there, but if you use these words to formulate your questions, it will prompt the witness to explain what they saw. Who was there? Oh, I saw Flotsam, Jetsam, and Ariel. So that's kind of why if you really like sit down and make the questions follow this format, you're going to be delivering the information in a way that allows your witness to establish the evidence. You need to really plan your line of questioning with the witness. And this is not like telling them what to say, you're obviously not making up what they say, but it's establishing like the order, the important things that they need to say, because it's really difficult if the witness needs to establish that something that she said, like if I need Ursula to establish she told Ariel the term of the offer was that she would turn her into a seaweed thing. And if Ursula kind of misses that, then if there's a whole dispute about whether or not Ariel should be turned into a seaweed thing, like it's very hard to bring up without leading the witness. So also for direct, you should absolutely know how your witness will answer the question. So that is just careful preparation with the witness statements. So the time is limited. So you need to tell a story, but you need to focus on the important points. I mean, these witness statements are long and like, we're not just reading them. You need to focus on things they say that are directly related to the elements of the claim. Like we talked about before, consider taking the sting out of problematic issues so that they can be explained by your witness first. We talked about changing facts in their statement. I think that's a really good thing to always bring up during direct. Because otherwise it's just easy cross points for them to make, and for it just kind of to look like you're hiding something. So here's some examination, direct examination of Ursula. Jessica, if you would like to answer them. Hello, what's your name?
My name is Ursula.
And what's your occupation? What do you do for a living?
I am some people call me a witch, but I really am just a mistress of the chemicals and potions and things of that nature. I'm like a herbologist, basically.
Great, great. So why are you here today?
I am here because I made a contract with Ariel and she breached it because she is just not very trustworthy.
Yeah, oof, that's frustrating. So when did you first meet Ariel?
Well, technically I've known Ariel like most of her life because I'm like kind of related.
Yeah.
But in this situation, you know, we really didn't talk very much. We really weren't around much. But one day she came into my cave and wanted some help because she had met someone she had fallen in love with.
Oh, and did you help her?
I absolutely helped her.
Okay. What did you do for her?
Well, Ariel, the thing is, she had fallen in love with a human and didn't think he would accept her as a mermaid. And so she wanted to become a human. And so I agreed to help her become a human. But I, of course, like, as awesome as I am, I do have to get paid. I can't do things for free because
Right.
then like people would just be bugging me all the time, right? So I do require things in exchange. So we entered into a little contract. I turned her into a human. And then she didn't follow her side of the contract.
So what were some of the what were the conditions on you turning her into a human?
Well, first of all, she had to give me her voice, and then if she didn't kiss this prince that she was in love with, she was going to be turned into a you know, like little seaweed pet. But that's just a way to show, you know, the ocean that she's not trustworthy and doesn't stick up to her word.
Right, right. Um,
Mhm.
and then did you turn her into a human?
Yes.
Okay. Okay, great. So that's just an example of like how you see how like she had to explain everything. I wrote this question here, did you perform your side of the contract? Because sometimes you want to like get little phrases in. But when we're just doing the general direct, the what's your occupation? Why are you here? When did you first meet her? What did you do? So that allowed her to just tell it her way, tell what was going on from her perspective.
Yeah. And so to be clear, a leading question suggests the answer is not necessarily a yes or no question, because if she said, did you turn her into a human? That's a yes or no, but it doesn't tell me what the answer is. I'm free to say yes or to say no, depending on the facts of the case, right? And then I think a good follow-up there would have been, and was that part of the contract?
Yes.
Yeah.
Okay. So, here's some more. Sorry. Oh, so here's direct examination for Ariel. So if I was Ariel's lawyer. Hi, Ariel. Where do you live?
I live in the ocean.
Oh.
I actually don't know what the answer to this question would be.
I know.
Where we
I
are
put
in this
that there.
story,
Like,
like
I think there's more strategy to be had about what she says as an answer.
Correct.
What do you like to do?
I love exploring. I love finding human things and trying to figure out what they do and how they work, and just like really love exploring the world and finding out about new people and new cultures and stuff like that.
Do you, how about, so this is an example of how I didn't script this with her before. And so I would wanted to have established that she likes to sing, because I wanted to talk about like how the voice aspect of this and how like she used her voice and it was kind of neat to take it away. So anyway, that is something that like strategically.
My attorney didn't prepare me very
I
well for
didn't,
these
I didn't.
questions, so
That is an example of why you don't do that. Also, it's hard to prepare for Ariel because she is losing this case. So Ariel, how did you first meet Ursula?
well, like always known about her because she's the big scary sea witch, right? And so everyone knows about her, but we kind of like avoid her cave. But I also know that she's got like cool magic powers and can help people do things that others can't. And so I just was really desperate. And so I went to meet with her to ask her for some help turning into a human.
Okay, and why did you want to turn into a human?
Well, I during one of my explorations, I observed a ship and it had these humans on it, and it was so fun watching them and watching them dance and watching them, run about on top of the ship. And then I just thought like, oh, that would be so cool if I could do that too. But then there was this one really handsome guy, and I ended up having to save his life, but I just like I wanted to get to know him better, but he was never going to accept me as a mermaid. So like I just felt like I had to be a human to even have a chance of getting to know him better.
Did you want to be where the people are?
Yeah. I was trying not to like quote songs there.
I know it's so hard. Okay, so now we talked about how we're doing just direct with our witnesses. Now we need to also establish foundation and enter evidence. And when I'm saying enter evidence, I'm talking about the exhibits. So exhibits and demonstrative exhibits. So you have to do this through a witness. You can't just like stand up and be like, and here's a contract. You have to establish, or here's the shell with her voice. You have to establish evidence can only come in when it's given by someone with personal knowledge. So a witness can only testify about things that they have personal knowledge about. So a witness can only talk about a document if they have some knowledge about the document. So the best time to introduce and use evidence is during direct, because you can kind of plan it. And that way you're making sure during direct examination, which is your case, you're making sure you're getting in the things that you need to. So that's the default best. You should absolutely be making sure that you're entering exhibits in during direct exam. There's almost always like one or two key exhibits that you should be entering in with like your main witness. That being said, do not be afraid to enter and use an exhibit during cross-examination. I like doing that. And I also think that it can be really compelling to a jury, because you're essentially having the other side's witness kind of like give good information for your side. So it's persuasive. So you have to ask your witness questions to lay foundation for the document. And you have to establish that they have this personal knowledge of the document, whatever you're going to have them testify about. I'm saying document, record, whatever you're going to have them testify about with respect to this record, you need to show that they have personal knowledge about it. And essentially, I didn't just tell her to say something she's never known about before. So you go through this process of entering the exhibit according to Rule 4.20. So, how I told you to go and pull out the elements of the cause of action. Go to your mock trial rules and pull out Rule 4.20 and memorize it. if you memorize one thing, I would do that. So here's kind of the process for introducing evidence, and it kind of like takes a long time, but if you can kind of like memorize each of these things that you do as you're entering the exhibit, it'll just kind of become second nature. I actually like to think about it sometimes as doing like a running commentary of what you're doing, and I'll kind of explain that part of it. So for, oops, oh crap, hold on. Okay. Okay, so the first thing you're going to do, like, for example, if I am going to use the scroll with either Ursula or Ariel, you're going to want to set the stage that you're going to talk about it without like getting into it. So you're going to want to ask like some type of preliminary question to flag that like, this is what we're going to talk about next. So if I'm doing directive Ursula, I'd say, did you and Ariel write these terms down in a scroll or a document of some type? So that's kind of an example of like how you'd flag it. So then you take out the exhibit and you identify it for the record. So a lot of this is just making sure that like the trial transcript is going to be very clear, and making sure the jury is very clear of like what you're looking at, so that they can refer back, so that we're all on the same page. So I have in my hands what has been marked as Plaintiff's Exhibit X. I'm just going to use that. Identify. So I identified it. It's been marked as Exhibit X. Your Honor, may I approach the witness with what has been marked as Exhibit X for identification purposes? I put that in there, but sometimes during like the preliminary part of the trial, the judge will say, you don't have to ask me to approach, but I would just plan on doing it unless you're told you don't need to. Next, after you take it out, identify it, you need to show it to opposing counsel and provide them with a copy. So this is where it's like you're running commentary of what you're doing. Let the record reflect, I am showing opposing counsel a copy of what has been marked as Plaintiff's Exhibit X. So you're just kind of like saying what you're doing. I have Exhibit X. I'm going to show opposing counsel Exhibit X. Then you give it to the witness. Let the record reflect, I am showing the witness what has been marked as Plaintiff Exhibit X. You don't have to do all of those things all the time, but if you get in the habit of like saying it, then it does become second nature and it's not so much of a like a burden. Then you have the witness identify it. So I tell them, I'm handing you, it's been marked as Exhibit X for identification purposes. What is it? So that's a good, I always like as a default, what is it is a good, just having them identify it, because that almost immediately is going to establish that they're familiar with it, right? So the witness identifies it, then you're going to do foundation. I will get to that in like just a few slides, but know that witness has to identify it, then foundation, then you offer it into evidence. So basically you're saying this record or this document, we've established that it's admissible evidence. And so now you're asking the court to put it in the record as something that the jurors can refer to and rely on when they are considering whether or not you've proven your case. So, Your Honor, we're offering Exhibit X into evidence. So at this time, opposing counsel might object to the evidence. So this is when the court would handle them. We will also talk about objections a little bit later. But just like process-wise, you're offering in the evidence, just know that there might be an objection there.
Yeah, Stacy, if I can just jump in.
Yeah.
I will say for the most part in our competitions, when you say, Your Honor, I'd like to offer Exhibit X, the judge is going to say, is there any objection? So
Yes.
you don't necessarily have to jump up screaming or anything of that
Yes.
nature. The judge will almost always guide you.
Mhm.
And if for some reason the judge isn't doing that, then you can say, Your Honor, I do have an objection if the court will hear it.
Yes.
And so
That's a very good point. The judges are very good generally at like making it clear like whose turn it is and if they expect, inviting you to speak if it's, appropriate for something like that. So the court deals with the objections, then the court will say whether or not it's admitted based on the objections. And then you asked to publish, which is essentially like showing the exhibit to the jury. So that is especially important where it's something that like a scroll where like you want the jury to see Ariel's signature on that. You want the jury to see that it says, I will turn you into a seaweed pet and you'll be mine. So it's you don't have to, but it's good practice, and practically we don't always actually ask. It's going to go into the record, and so the jury will have it. But when it's something that is kind of your primary piece of evidence, you're going to want to give it to them the jury right then. So now that the jury it's into the record, the jury's got the document if you want them to see it. Now you actually go into the questions about the contents of the exhibit. So that's when, okay, now I've done all the things I need to do to enter it, and now I'm going to actually get into what I want to talk about. So, Ursula, does this scroll explain the specifics of your agreement? Well, what does it say? Did you sign it? Do you have her sign it? Oh, is that your signature? Oh, did she use a fancy pen? Things. I mean, I'm just kind of being funny, but so that's when you have to do all of those things before you can actually get into the substance of all the stuff that was in there in the scroll, because if you haven't laid the foundation first, you're going to be fielding a lot of objections, and you might not be able to get into the substance until you've laid the foundation. Okay, I said that already. Okay, so I'm going to do an example for a business record because the scroll is a business record. So these kind of the requirements for foundation for different types of evidence are in the mock trial rules. But this one is probably one that's going to come up in almost any civil case. So the rules for foundation is that the witness has to have personal knowledge, and they have to establish that the record was made as a part of their regularly conducted business activity. It was made at or near the time of the particular event, and the record is in the same or substantially the same condition. So now we're going to kind of lay the foundation for the scroll as a business record with Ursula. So Ursula, Jessica, I've handed you what has been marked as plaintiff exhibit X. What is it?
That appears to be the contract that I signed with Ariel.
And do you make these types of scrolls as a part of your Sea-Witch business?
Absolutely. Every time I do it, we put in writing exactly what they want, because if we don't, people always come back and complain you didn't give me the right color legs, yada, 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 yada. So we put in writing exactly what we're going to do. Okay.
And then is this scroll an accurate representation of the scrolls that you use?
Yeah, it looks like it's on my letterhead. It's got my name. It looks exactly like one of my contracts.
Okay. And was this specific scroll created at or near the Poor Unfortunate Souls song?
Yes.
And is this scroll in the same or substantially the same condition as it was when it was created?
Yes, it looks like, and it looks like it is the exact contracts that we signed.
Great, thank you. So now I have just laid the foundation that this is a business record. There we go. So that is how I have used those, entered those during direct examination. Now for cross-examination, which is so fun. So I think that I'm not saying that direct examination is very important because it is actually telling your story. Cross-examination is really fun. It's done well, it can be just so incredibly effective. So after the opposing party presents their witness, you cross them. And the purpose is to poke holes, discredit the witness testimony, sometimes even to establish points that help your case. Oftentimes in mock trial materials, there's going to be, the witness's testimony or statement is going to have a lot of facts in it, and some of them are going to be like helpful for your side. And I remember a couple like problems we've had where like you had to get out to prove an element of the claim, like you had to get it out through cross. So whereas in direct, the witness is completely the star, in cross, the attorney is the star of the show. You are controlling exactly what is said. And so the witness should really be doing very, very, very little talking. I want the jury to hear the points that I am making about this, all these facts. I don't want to hear, I don't want to give that witness the opportunity to, tell their story. I'm telling my story through my questions. So cross-examination questions should be closed questions, not who, what, where, when, why, how. So this is where your preparation is going to come in. I think if you spend the time to make your questions phrased the right way, it will pay off. So phrase your questions so they can only be answered with a yes or a no. Definitely stay away from why and how, because those are going to call for an explanation. And even if the explanation is innocent, it just allows the witness to like launch into something that you don't know what they're going to say. You want to be the one that's the star of the show and giving information to the jury essentially. So when you're sitting down to do a cross, you need to know exactly what points you want to make. So you need to phrase your questions really well, make your specific points, and also know when to sit down. I think we've all like argued with people before just in life, and that, like if you just try and discredit everything, you kind of like lose it. It's not that interesting anymore. You really want to go for the jugular here. You want to make sure that you're highlighting these points, and then you need to sit down then. So let's do some example. Oh gosh, I have like things in my screen, sorry. Okay, so an example of the attorney for Ariel, so defendant's cross-examination. Oh, sorry. Example of, this must be Ursula. I'm sorry. Ursula's attorney's cross-examination for Ariel. So I'm crossing the defendant. Don't look at the title, my bad. Okay. So these are related to like the offer and acceptance. So Ursula told you that you'd have to kiss Prince Eric by sunset on the third day, didn't she? Ursula told you specifically it'd have to be a kiss of true love, didn't she? And Ursula even drew you pictures in the air showing the kiss had to be a kiss of true love, didn't she? So if Ariel wanted to kind of be like, well, I mean, I don't remember, that would be great. I would love to introduce pictures of, the little heart that was in the air, show that to the jury to just, let me refresh your memory. So each of these have like a didn't she, correct, and they have enough facts. They limit the facts to what I want to talk about. So like related, keep going. You read the details of the scroll. I watched parts of the movie earlier. So, and you see her kind of go like, and you see her kind of like make a face and like doesn't look happy. And so you didn't even like everything you saw in the scroll, did you? No, you didn't. But you still signed it, didn't you? And then sometimes I like another way to like do closed questions is yes or no. And that's a good like ender, or it's good when they are squabbling and are not, just like they really don't want to admit to something. Another one is true or false. So like those are also ways and that's on like your key points where you're like, all right, Ariel, come on. True or false? You wrote your name on the scroll. And she has to say true.
Yeah, I particularly like yes or no questions. Like, this is a yes or no question. Like when the witness is really dodging answering
Yes.
the way that they should. And then it's like, okay, I'm asking you a yes or no question. Did you sign the
Yes.
scroll? Yes or no? And then they're really forced into having to answer. And if they still try not to answer, then it's a great objection moment.
Oh, I'm sorry. I like stopped. I have more slides. I don't know why I said that, guys. There we go. Need to share again. Okay. There we go.
That's, yeah, controlling a witness on cross right there.
Yeah, there we go. I just have like all these. There we go. Okay. So controlling a witness on cross. Yes, sorry, I don't know why I stopped there. So this is critical. Sometimes a witness like is so easy and they just say no, yes. And sometimes strategically that's the right move. Sometimes, and I think in mock trial, you'll see a lot where witnesses just don't want to answer a question, or they want to launch into like their explanation when you did not ask for it. So yes or no questions. Why is this? I'm sorry, guys. I don't, something's messed up here. So that was a very short explanation of how to control them on cross. I think so. One of the things that you can do is if they still won't answer your question, yes or no, you can essentially ask the court to instruct them to answer the yes or no question. You can only do that if your question is a perfectly closed question. So don't try and do that on the fly. Do that when you know that you've thought about the question, it's yes or no, you know, the witness statement's clear. That's when you ask the court to instruct them to.
Yeah, and I got asked in a private message, does it help or hurt witness scores? And they're able to avoid answering yes or no questions. So if it's a real yes or no question, it's going to hurt your score if you're just refusing to answer. But if it's not a yes or no question, answer the question that is asked of you, not what you think they intended to ask.
Yep.
On cross, that's what I always tell my witnesses in real life. But that will get you points, because as a presiding judge, I'll get, objection, non-responsive. They didn't answer the question I asked. I'm like, actually they did, because you asked an open-ended question. Like I know what you're trying to go for, because I, at that point I've read the problem. I've probably sat through multiple trials. But if you ask an open-ended question, they're allowed to answer however they can within the bounds of that question. And so that's when coming back, it's like, ooh, okay, I made a mistake. I asked something too open-ended. Let me come back and ask yes or no. And sometimes as an attorney, I will say in mock trial, there's very few circumstances on cross where you want to ask an open-ended question, right? Stacey, would that be fair?
Yeah.
In real life, sometimes we'll ask open-ended questions just to see how ridiculous the response is.
Yeah, absolutely.
But generally in mock trial, we don't leave a lot of opportunities for that. It's more a skill of like making sure you're asking as many leading questions as you can. Now, obviously, like, when did you first meet her? Like, there's not really, unless you know specifically, you first met her when you went to her cave. Yes, correct. Great.
Yes, check. Moving on. Yes, and okay,
and what, for clarification, somebody asked, so if you're the witness and you're being crossed, to say yes or no and not explain, I would say no.
Correct.
No, but no, but yes, but like, try to get your explanations in, because it's on the other side to cut you off. But there may be a point where the judge is like, stop.
Right. Yep.
I get that you know how to dodge. Let's just move on.
Yeah. I would say for witnesses particular, like, try and do your explanations and stuff, but like read the room. So like if the judge has now instructed you to answer the question multiple times, or if the attorney has had to another way to control witness, I think that can be very effective is doing the, okay, I've asked you 3 times now, whether or not you sign the scroll. Something, you know, or something like that, or whether or not,
Let me I'll give an example.
Yeah,
So like
thanks.
I'm cross-examining Ursula,
Mhm.
and I want to get in that this is all just a ploy to turn people into seaweed, right?
There we
That's
go.
all
Yes.
any of this is. And she's gonna keep avoiding, no, it's their
It's like,
fault.
no,
No,
I
no, no,
help
no,
people.
no. And it's like, Ursula, isn't it true that 100% of the people you sign contracts with get turned into seaweed pets? Yes or no?
Yeah,
True or false?
exactly.
And then she's like, true.
Yes, that's great. So I think that's another way to control a witness, and like, yeah, they go off the rails a little bit first, but then like kind of like letting the jury be exasperated and then doing that, like,
Yeah.
almost like parental, like, I'm gonna ask you one more time. That can be very effective, because you've got to try kind of all the different things with witnesses that you really don't want to talk about something.
Yeah. And if they answer the yes or no question with a yes or no, and you just don't like the answer, that's when you need to bring in evidence to show that they're lying or not credible or whatever. Yeah.
So that is kind of, I think we have the other slide decks about like evidence, but I think that it's more important to create the right questions, lay the foundation. Let me pull up these slides about tips for.
I think objections is probably what they're gonna wanna.
Yes. Oh yeah, here they are. Hold on a second.
Yeah, because like I mentioned in the intro section, in terms of how to get the exhibits in, we have a pretty decent like format in the rules for you to follow. But generally, you know, the general format is like, what is the thing? How do you know what the thing is? How do you know it's really the thing?
Yes.
I offer into evidence.
How can we be sure this is the thing?
Yeah.
Okay, so so the process we talked about, well, just to give you the process first. So to object, if you're objecting to a line of questioning or what they're going to say, or to an exhibit, you stand up and you state the objection to the court, and the reason. So it's a short statement. One thing I think is just good to flag, which I did wrong the first time I did a mock trial and really got marked down for, is you are always addressing the court. You are never looking over to opposing counsel and being like, objection, that is not correct. You know, like, you are never talking to them. You are always talking to the court.
Yeah. And I will say that's a tip for real life attorneys too. I had that happen in a trial. Opposing counsel stood up and looked at me and started making the objection at me. And the judge was like, excuse me, excuse me. That's for me. Thank you so much.
I'm in charge here. Thank you. Yeah. So an example is like, objection. This is prejudicial and prohibited under Rule 403 because it's more prejudicial than probative. So you don't, you know, you might not remember the rule numbers. That's fine. But you need to remember like this is prejudicial, and it's more prejudicial than probative. So something like you need to remember those phrases, and that's just a short statement about what it is. So for example, if you were going to bring up the question about the percentage of Ursula's clients that had been then turned into seaweed, you know, I would probably object to that line of questioning and be like, this is completely prejudicial, has nothing to do with the contract, and it's more prejudicial than probative to any element of the case. So if you can tie it into exactly what it is, you should, but you want to keep it short and clear. The party who is trying to enter this information is going to respond. The court generally will look up and say like response. So an example, like to respond to this one up here, listen to what the person objecting says, because that is what you're responding to. So, I mean, honestly, sometimes if they're not making sense, do your best, but like use the words that they're using too. So, so I talked about the prejudicial value. So, you know, responding and saying, this is, it's always say it's relevant. I think that's a good like rule of thumb. It's relevant to this element, but any prejudice is outweighed by the probative value. This goes directly towards her motives, her habits. She runs a bad business and she's doing bad things. Something that is not what you say, but you're going to use these prejudicial probative. I'm using the exact words that were in the objection to respond to it. So even if you're not exactly sure the rules, you're going to listen and respond. As long as you're like using the same words, you're doing your best. Then, oh, sorry.
And you can make multiple legal objections at one time to a question. So you could stand up and say, Your Honor, I object because this is hearsay. Also, it's more prejudicial than probative. And I, as a judge, might be like, actually, I think it's super probative, but I agree that it's hearsay.
Yeah.
And so I'll sustain the hearsay objection, right? And so I've done that before. And so then that kind of puts the burden on the other side. So one of the things I try to do with every single exhibit that I'm going to put in, I try to think about what is the best objection that they're going to make to this. So, and what's my response going to be?
Be prepared. Yep.
And the same for questions, especially like they're not going to object when you ask the person's name, right? So you don't really think about that. But when you start getting into the elements of the contract, getting into who said what the offer was, what it wasn't, some of those questions may be objectionable. So think about like, okay, what objection would I make to this? And so then what would my response be so that in the moment, in the middle of the competition day, when the other side objection, hearsay, you're like, no, Your Honor, it goes to the personal, you know, it goes to her emotional state, not what she was trying to say, you know, or Your Honor, I'm asking what she did in response to it, not, you know, the truth of the actual statement.
Yep. So like similarly, the one that we just did was like prejudicial. This one is just a response that like mirrors the grounds of the objection. So objection, Your Honor, this is prohibited hearsay. It's an out-of-court statement being used to prove the truth of the matter asserted. And so if I'm responding after the judge's response, say, this is not hearsay because it is not being used to prove the truth of the matter being asserted. It is being used to show motive. Something like that. So what I'm saying is I'm basically just saying, no, it's not being used to prove the truth of the matter asserted. It's being used for something else. So at least if I haven't thought through it, I've got a little bit of a script because listening is really important when it comes to objections.
Yeah, and I will say for objections, don't get your feelings hurt if at some point the judge stops asking for responses and just rules. That is usually the judge's signal that like you guys have made this same objection several times, you've argued it several times, you know the rule, I know you know the rule, we're just going to kind of move this along a little bit faster. So don't get too kerfluffled if that happens, because I will do that as a presiding judge. I'm like, this is the fifth hearsay statement that the defense has objected to. They know that it's all hearsay. Great. Kudos to them. The plaintiff knows the exceptions to the rules of hearsay. Great. Kudos to them.
Yes.
We're just going to expedite this now.
And so just like go over it, the court will rule on the objection. If they say sustained, means the objecting party wins, evidence does not come in. So if you were, you know, like trying to get the document in or trying to ask a witness about something, there was an objection and the objection was sustained, don't keep asking that question. That document does not go in. So just don't. I just want to make sure that's clear, because if you kind of forget, I mean, real judges wouldn't like that.
And I would also say, if you are on direct, you're directing your witness and you get objected to for leading and it's sustained, be prepared, like shift re-ask the question in a not leading manner. There's that one movie where he gives objection leading the witness and he's like, what happened next? It's like every single time he just starts going, well, what happened next?
And then what happened next?
And then what happened next? And he's like, and then you went to so-and-so, and they're like, objection leading. Where did you go next?
Yes. Yeah. And so that is actually good. If you and your witness are kind of like forgetting where to go, sometimes you just lead them to flag I mean, that is a good thing to do if like your witness is not picking up what you're putting down. And you need them to say something. That actually is like a great example of
Yeah,
sometimes you just give it up, do it.
I had to do that one time in one of my cases. My client forgot that she had taken pictures of something, and I was like, did you have documentary evidence? And she was just like, oh, and I was finally like, did you take pictures on January 15th of the, and he's like, objection leading. And I'm like, great. So did you ever take any pictures?
Yes.
And she's like, yes, I did.
Yes, it definitely like, and I think too, especially in mock trial where like there's a lot of material. So that can be like, and you do need to prove your elements. So if it's really critical, like sometimes lose, that's fine. Okay, so I think for handling objections, I think one of the keys, like as a presiding judge, is I honestly sometimes don't, when I'm judging, in terms of giving you a score, I care less about what you say. I care about if you can stay calm, look like you're in control, and move on. Because oftentimes, like a jury doesn't know the rule of evidence. They know if the judge, like if they won or lost kind of, and then they know, like if you get all upset because, you lost an objection ruling, then they're just like, oh, something bad must have happened. Their case must not be as good. So now for purposes of actually like winning the objection so that you can get in the evidence you need or keep out evidence you don't want, it's important. But for purposes of like advocacy, staying calm and collected and moving on is really important.
Yep. And there are presiding judges across the state who will intentionally rule incorrectly because they want to see how you handle it. They want to see how you handle that hearsay objection being granted. Can you rephrase the question? What can you do with it? What else can you do? Because I like one of the sadder rounds I sat through like 4 years ago, I guess, is she kept getting objected to and they were sustained because they were sustainable objections, and she stopped asking questions. Don't do that. Keep asking your questions. Try to figure out, you have time to prepare these questions. You've got to, at this point, 2 months before most of you compete in your regional competitions. Go through each of your direct questions and make sure they're not leading questions. Again, there's some things you can lead on gently, like in the beginning, if you're just establishing who this person is and you live in the same ocean as Ariel, isn't that correct? Like, technically it's a leading question. No one's gonna care.
Who cares?
Like that doesn't really go to the substance of the case. So, but you've got plenty of time to work on those things. And so that's a general tip.
Yes.
I would give you, but again, like if you're asking about out of court statements, be prepared to know what your exception is every single time. If if something's super prejudicial, be prepared to argue why it's more probative, right? Like why it's so important to your case. Like, okay, yeah, it's super prejudicial that she turns people into seaweeds all the time, but the more probative thing here is that like this is clearly a ploy to turn people into seaweed. Like there was no intent on her part to really adhere to a contract.
Yeah. Or to say like she said she's trying to help people, but she's really not trying to help people. She's trying to get more seaweed people in her lair.
Exactly.
Yeah. And I think the rephrasing, be prepared to back up to establish foundation. Those are things you prepare, but also I think, knowing what points you need to prove, what you want to hit on direct. And if you're having a really tough time, if objections are, like being sustained and you like can't get something in that you want to, like move on to like a different chunk, move on to like the next point you need to make and try and circle back. Maybe, like you might just like say it a little bit differently the next time that works. So I think that definitely try at the time, like do your best to get it in. But then if it's important, but it's not working, like if you're prepared and know the other points you should make, you can absolutely circle back. give yourself a moment. Let's see. Yeah, like, oh.
I think at this point, do you have anything like super critical, any last thoughts you wanted to share? Because we might want to open the
Yeah, I think let's open it up. That's great.
for questions, because we've got about 7 minutes left, and we want to try to get you the answers that maybe you have that we haven't gone over yet. So if you have any questions, you can turn on your video and your mic. You can say it out loud. You can type it in chat. You can send it to either of us directly. If you don't have any questions, you're free to leave. It's really up to you guys. Stacy, I'm not seeing any questions. Do you have any questions?
Okay, wait.
I don't know where the recording will be posted, maybe on the website. But Melissa will send that information out to all of you. So I was asked a question, are there any good movies to watch in order to get familiar with how the court works, Stacy? I personally love My Cousin Vinny because as ridiculous as some of it is, it actually does show you how a court works, and gives you an idea of like how to ask questions, how not to ask questions.
Yeah.
How not to act when you get frustrated.
Yes. Yes. And I think it's a good lesson in saying that like advocacy does not look one way. Like all different people can be effective in different ways. I think, I don't know. I think My Cousin Vinny is probably the best to actually like watch. I think there are, I also
minus the opening statement, because I would not mirror Vinny's opening statement. It is hilarious, but I would not use that for yours. But everything else I think generally follows like a court case.
If you're like very into just like kind of the behind the scenes and like strategy, but then also seeing it play out, I think the O.J. Simpson, I think it was like made on Netflix a couple of years ago. I thought was actually pretty good. Obviously it's like more issues, but I think like the actual trial part of it was like you got to see a good kind of glimpse into some of that stuff.
So how should a witness react when there's an objection? You stop talking is the answer. You don't react poorly. I had a witness, I was saying that I had a dock points off of a couple of years ago. He was objecting non-responsive, and she was being non-responsive. But every time he said objection non-responsive, her response was, I'm answering your question. I don't know why you're objecting. Don't do that. Don't be that witness. That will lose you points as a witness. When objections are made, it's between the attorney and the court, not between the witnesses. So, and then last time, again, for dress code, do clothes have to be solid color or can they be patterned? I showed some examples of people wearing patterns. You can wear patterns to your heart's content. We really try not to judge based on dress at all in our competition, as long as you're not wearing things that are just largely inappropriate. You do you, guys. So
yeah. Yep, just because I think the comfort level too, like, you know, like if you decide to wear like a skirt or something, like just make sure you're comfortable sitting down in it, you know?
Right. Make sure you can sit down in it, right?
Yes. Yes. That's problematic.
But yeah, I'll stay on for just a minute or two if anybody else has questions, but we're going to wrap it up and stop the recording here. Thank you guys so much for attending. We love doing this for you, and we can't wait to see you at competition.
Thank you so much. Good luck, guys. So excited.